My name is Dion. I'm the chair, and tonight we're happy to have committee member, Vice President Maureen, Board Member Kara Coates, President Pico Antonio, and Board Member Horn. Also, and anyway, so we're going to start, and we have tonight we have several policies. We're going to be introducing 2 new policies, and we're going to start with 4 policies that have to do with weapons. We're going to group them together, and then we're going to move on to several other policies that are a lot of updates due to House bills and Senate bills, and a couple of, like I said, new policies that we're going to introduce. And so I'll be turning it over to Superintendent Deal.
Good evening.
And then also Treasurer Gooding when appropriate.
Yes, good evening, everyone. We do have a slew of policies that have been recommended to us from Neola. And as Mr. Manley stated, the majority of these policies are coming as a direct result of state legislation. In the first one, really the first set of 4 regarding weapons is directly related to Senate Bill 215 and House Bill 99, which became effective just this last summer. And it is defining what a qualifying adult is for someone who can legally possess a firearm. It does change our policy to adhere to the new state law, particularly with the ability for someone with a concealed carry permit to when they can have that in a school zone, and that it needs to be properly secured. So we have reviewed these. I have spoken with our SROs about this policy as well, and I can entertain any questions that you may have.
I have a question just about how the policy is organized, I guess. How I'll frame it, it's not a substantive question. It's so, for example, on 1617. I don't know if this is a pattern in all 4 of them, so I'm going to start with the one that I'm looking at right now. And that's 1617 under exceptions to this policy. To me, it looks like paragraph A should maybe be paragraph A and B. So where it says weapons under the control of state or federal agents authorized to carry deadly weapons who are acting within the scope of their duties or law enforcement. And then to me, it looks like it should be then B, weapons carried, because it's a whole different category of individuals. The second part of that, the weapons carried by security personnel employed by the board who are qualified. I guess I'm not sure why those are both A. I don't know if that question makes sense, but
it does, and I cannot speak to why this is how Neola has recommended it.
well, it almost looks like it was 2 different. What I'm thinking is that in the future, there may be additional things that get added to one or the other of those, but not both. And so it doesn't make sense to me that we keep them in the same
So
letter.
would you recommend? So am I hearing you recommend that weapons under the control of state and federal agents be A, weapons carried by security personnel would be B?
Correct.
And well, that's in so A, B, and then letter B would become C.
Yes.
It almost
Okay.
looks like if you go to C, that C is kind of what you're creating B with, right? But it's all been stricken. Yeah.
That's right. And that is the provision for those boards of education that wish to allow teachers to carry, which we do not wish for. And so that's why we did not adopt that change,
Which, I mean,
or I'm not recommending.
and I
Yeah.
agree with that recommendation.
Yes.
And I just still think that we should probably separate
Absolutely.
those two categories, just because, like I said, we may at some point either be required or desired to add additional things to one or the other, but not necessarily both. They're just not this necessarily exactly
I see them as separate.
situated the
Yeah.
same.
Again, I see what you're saying.
That is,
Repeated.
it is repeated in the other policies, so we will make sure to make that change when we bring this to you all for approval. Okay, thanks. Anything else with this set of 4 policies?
Well, right after H, how do we notify the public? There's that whole new paragraph of the board will notify the public using regular channels of public communication.
This will likely never pertain to us because this again is for those boards that elect to allow others not noted in letters or new letters A, B, and C to carry weapons.
But
So if
that's
we
not
are,
inherent in that, the wording. I would not have made that assumption
right,
that you're just explaining. So
So maybe it should say the boards,
to
if
me, it looks
there
required.
are individuals beyond, so I'm not getting the wording right, but if there are individuals other than those listed in A, B, C,
Yeah,
yes.
it has to have a
Then we would know.
qualifier.
Yep.
Right.
Yes, so I would have it, just quickly looking at this. Down at the 3rd line, a list of qualified individuals who have received written authorization. I would add beyond what has been identified in A through G of them.
Yeah.
And I would do that with all 4 policies. Okay. Great recommendation. Anything else?
Nothing else? Okay. Actually, I'm thinking maybe we want to change the order and take policy 6234 next,
Okay,
the district participation. Board of Revision.
sure. Absolutely.
All right, let me find it. So that's due to House Bill 266. So policy 6234, district participation and board of revision proceedings.
There are.
It's.
I log in, did you share a screen? We do it that way.
Is it not on that?
It's in the folder. It is, there are 3 of them. There was the original draft.
Here's the,
There's an original draft, which is draft.
Oh, I see.
Then there is draft
Does anybody-
1.
I have extra copies. Does anyone need? one?
The comments for the ones that Dion had. Draft 2 is the final recommended policy.
Draft, so look at draft here.
Draft 2, that's the recommended policy. We had an original, so I'll just.
Does he need? the draft?
No, I have it.
Okay.
I got it, thank you.
Okay.
I got it.
So
I want it.
so everybody has, so. Yeah, the draft 2, because, so I'll explain how we got to there, and Mark Gillis is here, from Rich Inglis Law Group. We talked about this policy at, the last Finance and Facilities Committee meeting. So we had the original draft, which is the draft. There, then this week, we followed up to make sure we had additional eyes on it. So we also reviewed it with Merker and Eckler as well, so that Mark and I and the team at Merker were working through this. So there were some changes to that in the draft 2. So what ultimately came 2, which is what we have before us tonight. So this was a new policy. Neola had not seen this before, so that's why there wasn't anything there. It's something that Mark and I have been talking about for a while in response to House Bill 126, which passed and when it was effective became effective July 1 of 22 for tax year 22 cases. So we wanted to basically codify what our procedures are, why we do board of revision challenges. These are for, as we mentioned in the Finance Facility Committee meeting, this is only on business property owners. We want to make sure that we're doing our fiduciary interest to make sure that we are collecting the property taxes at the level that they should be. We are evaluating the sales data on those to make sure that there's an arm's length transaction. There are parameters that the board has followed previously. House Bill 126 changes that somewhat, and the annual notification approval by the boards, which we would do in February. So what we changed from what we talked about at finance to now, we removed, I guess, I'm trying to think how we say it. I don't feel that there weren't substantive changes. We kind of maybe removed what we may say is more of a, just the editorial or the opinion piece, because there's still some question about the
Yes.
challenges going on about the constitutionality of it.
Sure. Yeah.
So that's kind of where we got to, but
We had a lot of specifics listed in the policy. This covers those specifics in broader language.
and we wrote it in a way that with the parameters established in House Bill 126, currently it is based off of the sales, 500,000 or 10%
Correct.
increase, correct? We left it in there to reference the without saying the numbers, because it will increase each year. We don't know what those increases are going to be. So we wrote it this way so we don't have to come back and change it every year. Whatever's in state, whatever the valuation is, whatever those parameters are that are set, this will follow that. So that we left it that way so that we wouldn't have to come back every year and make revisions to the policy.
I do have. Just because I thought too, we were going to add some language about appeals.
That was requested.
I'm just reading.
You were asking about parameters.
I wasn't asking that we set parameters, but I was asking that the policy reflect what our process will be in determining when to file appeals.
It's
The
almost,
board
it has to
revision
be at the
decision.
policy level, or else it's gonna be at the administrative guideline level, and we're responsible. So we would have to set a policy.
Well, I wasn't asking that the policy necessarily set what the parameters are, but that it specify who will make the decision and
Yeah,
about whether or not an appeal is filed to a board of revision decision. I just remember, I'm sorry, Scott, I would have actually said that to you earlier when I saw these drafts. but-
That's okay. That's okay. I mean, this is the perfect place to.
Well, I mean, I thought that we had talked about that, I guess.
we did it.
That we
finance
were
committee.
going. And I'm just realizing that that's still not part of it.
I thought we were talking about parameters on.
Yeah, I remember
appeals.
an
We
email
were specific
on
on
parameters.
appeals.
What were the parameters?
So I did, I was
Right.
asking what the parameters have been, and then in response to that answer, I said that this policy, since we're now going to have a board policy that lays out what our process is, it should include whatever the process is going to be for whether or not we file appeals to board of revision decisions.
Other than the same. You're talking about the procedure saying that, oh, in it. I'm just gonna throw something out there that the decision to file that appeal would be made by the treasurer, for example,
If
if that's what the policy was, not a specific set of parameters
Right.
of financial numbers.
right,
Oh, okay,
or
Or,
that decision will be made by the board.
yeah,
okay.
at the,
I did address that a little bit in a response to an email with regard to the issue of timing. You only have 30 days from the date the decision is rendered to file the appeal. So if there's only one board meeting a month,
There's definitely more than one board meeting a month.
but we're still going to run into timing issues. The decision comes, the analysis of that decision and whether to appeal needs to be communicated. And then, and all I said was,
Yeah.
all I was bringing up was if the board wants to make those decisions on a case-by-case basis, then there will likely be timing issues because we don't know when the decisions are going to come out, when they fit into, and how that's going to fit into a board schedule.
So
We
I,
could do
so
a
I
special meeting.
understand all of that. I guess my point was that needed to be part of the discussion about the policy, whatever the decision was, whether the decision was that it was going to be the board or the decision was that it was going to be the treasurer. And if it was the treasurer, then it probably would have included some parameters from the board.
Because
But-
right now, the current practice is that there are no parameters.
I understand
And
that.
I'm the one making that call, right currently. And historically too, that's how it's been.
I
The
understand.
meeting in February.
That's to do the notification on these
Okay.
upfront.
So that's the bulk of them, or, so.
Yes, so what this
the
one is,
bulk
this
at
is
one
if there is
time, And then we'll have scattered
yeah,
miscellaneous
the
ones.
appeal
throughout
piece
the
is
year.
if the board of revision case doesn't go in our favor and we feel that there's some reason that it needs to be appealed, then what I'm doing is we're giving authorization to appeal that to the Board of Tax Appeals. So that's what's happening now. That's what so it's not the initial complaint or counter complaint, it's the appeal to the Board of Tax Appeals.
Whether it is we need additional information or we felt after analyzing the hearing that the Board of Revision was incorrect in accepting the owner's evidence or was incorrect in not accepting, in our instance, if it was an original complaint, the sale. But, you know, all the cases are different. Some are very
Right.
straightforward,
Right.
others can be incredibly complex.
Sorry.
The-
I get my overall point
Board
though is
approval.
that I think before we get to a point that we are. I understand that time is an issue, but I know that we asked for some language about filing appeal be part of the policy. I'm just not, I don't know how we do that in pieces, like, are we gonna then, if we do it like this and then amend the policy to add appeal language, that doesn't make any sense to me.
We
What-
just
It's December 1st.
actually,
so that's policy.
just trying to see where.
We put it in an accompanying
That's right.
AG and cross-reference that AG.
I think the policy has to have the language about the, not the administrative guideline.
Mark, you think we put that under the filing?
An
and counter
approach could
complaints
be
and
that
original
it's the
complaint?
treasurer with the finance committee representatives that reviews them, right?
That's,
I mean,
I
that's,
think,
we need to have those conversations,
Yeah.
but
yeah, I mean, I
the
actually.
appeal piece definitely.
I understand what you're
every
saying
month.
about the timing. I do understand that. What my hesitation is, just to be completely candid, is that my understanding is that in the past, it has been that we 100% of the time file an appeal.
No, we do not.
So,
It's based upon the level of, it's based upon the Board of Revision's decision and whether or not, after analysis of what was presented at the hearing, the Board of Revision's decision reflected the proper balance.
right, so if the decision isn't in our favor, then we file an appeal.
In a general sense, you wouldn't do it in every single case. If it isn't in your favor and we believe the decision was wrong.
We must believe it was wrong, or else we wouldn't have filed the counterclaim or the,
Well, not necessarily. After the hearing, we don't get the
and I,
property owner's evidence until the hearing starts. So a complaint, if we'll use a reduction complaint, property owner has filed a complaint seeking a reduction in value. They may put a very general reason on the complaint as to why, or nothing at all.
right,
Okay, so we file a counter complaint, so we have a seat at the table.
sure,
We show up at the hearing, there's no discovery. I don't get all their evidence ahead of time and get to determine what we're doing.
right,
We find out for the first time when we sit there and they say, oh, well, here's what we have. We do our best to defend that or ask questions to make sure everything is fine. And then the board makes its decision. If that decision is adverse and we believe to be incorrect, we would file an appeal. If we believe that it's adverse but is correct, we don't. But we don't know any of that ahead of time, unlike a regular civil case where you're gathering information ahead of time and you can make those determinations. We're kind of flying blind because there's no discovery process or commission level.
okay, that's actually more information than I had before, so I appreciate that, but I think that is my point, is that there was no awareness by
Okay.
this board about how a determination was made about whether and when to file an appeal. And I do think if, I also understand the 30-day timeframe. And so I understand why we might want to default to the treasurer making that decision in consultation with the attorney. But and I'm not saying that that's I am one board member who's talking right now, I just want to be clear. But if that is what the determination is about the route that makes the most sense, then I think that this policy needs to say that. And I guess what I expected is that there would be a recommendation like that was
Okay.
part of this policy so that we could discuss it.
I was not aware that
that
it was specifically wanted to be included. I was responding to questions about what has been historical process and so forth over the last 25, 30 years.
Yeah.
And wasn't, did not understand that you wanted an actual
I
policy
think if we're
in here.
If
as to
we're
what that
going
would
to
be.
have a policy, which I think we should, I think we should lay out the entire.
Scott, to your question, if you're going to put it in here, yes, I would put it after the paragraph of filing original complaints. Or you could do it after the annual action and notification.
Because I was thinking the same thing between the original complaints and the annual action.
Right.
And then we would just have. Would just be title appeals.
Sure. Yeah,
I'm just thinking, because if we can,
because there's also
So we
appeals
can
from
Right,
you have an appeal from the Board of Revision. There currently is a question as to where to appeal that.
right,
Whether it's to the Board of Tax Appeals for current cases, for future cases that we haven't filed yet, but will file, you're going to go to the Common Pleas Court. But then you may appeal that decision, because
Right.
both of those are still administrative decisions. You may be going to the Court of Appeals
right,
and then potentially to the Ohio Supreme Court.
right,
yeah, and appeals work the other way too, because we've had this happen recently where we were successful.
Oh,
At
certainly.
Board of Revision.
You're defending an
level,
appeal.
and then the property owner,
Right.
then they took advantage of this and they appealed to the Board of Tax. So I mean, the door goes both ways on that.
I just think it needs to say, it just doesn't feel complete to not say
Okay.
something.
So we have a section of appeals. Mark, what do you think we should, appeals of Board of Revisions, appeals of decisions made by the Board of Revisions to the Board of Tax Appeals or other.
Yeah, don't be so specific.
Yeah,
Because
Right.
it could change.
couching the language, it would be. The board may appeal any decision of a board of revision. And then you've got to decide who's gonna make that decision, as determined by the treasurer, by the board, by a committee, however you're going to decide to do it.
Yeah, I mean, I'm just thinking through the other kinds of legal proceedings that we have. I mean, those are determinations that are made by administration. The expectation on the part of the board is that we're informed of those decisions. And so I think it needs to be maybe,
Does it make any difference? This is an administrative hearing and not a,
no, but I mean, typically so I'm thinking, for example, of, let's say a grievance through the collective bargaining process. That, I mean, that is essentially an administrative process all the way up until the point that it gets to a certain level, right? So we are typically informed, even at the very lowest level, when it's still internal to the district.
okay,
The expectation is that we would at least be informed.
oh, okay, but I mean, that could be the appeal is determined through consultation with the treasurer, with the board to be
Right.
informed, sure.
Yeah.
And
Board may
that
appeal any
alleviates the timing issue, because an appeal can always be withdrawn if the board says,
Right.
hey, we don't want to do this.
Right, right.
So if I go back to what you were saying originally, the board may appeal any decision of a board of revision. And we're saying as determined by the treasurer CFO with notification to the Board of Education
In consultation with the attorney.
in consultation.
With board.
Council. And notification. To Board of Education.
Yep.
Just writing some reads that one more time, make sure we got it. So the section will be a new section between filing original complaints and annual action and notification. It will be titled appeals. And it reads, the board may appeal any decision of a board of revision as determined by the treasurer CFO in consultation with board counsel and notification to the Board of Education.
I think that makes sense. Sorry, I didn't read
That's
the
okay.
derail. I'm just, it's
No, it's
striking
good.
me that it's
Detail.
not here.
I think it's what this meeting's. for.
Absolutely, absolutely. And Dion, thank you for moving this up. So I think you did that somewhere.
So
You
I
have to stay
have
over time, but yes.
Oh, yeah, we're not.
We're not done.
No, no, no,
No,
no.
Oh, okay, right.
Any other
Now we
questions,
start at the beginning.
comments?
Yeah. Well, I guess I would like to think that we could state the scope in that first paragraph of what it covers. I think the scope, we talked about this. I think, where was that? It really isn't defined until you get to, shoot, I have so many versions. That it's the commercial industrial
Oh,
with property used for commercial, industrial, or other income producing investment purposes. I think I think this was one of your points, right, Dion, that maybe add a sentence to the initial purpose paragraph that talks about the scope of this policy deals with
Do you have the wording?
commercial, industrial, and it's that part of that sentence at the top of the original second page. And in the third line, I think across the board policy is not a term that's I've ever seen in policy before.
Right.
Oh, the third line down. What does that add to the text?
you want to remove the across the board. Is that what you're saying?
Yeah,
Yeah, uniform and across the board. Almost redone.
I would like to delete across the board. Right, and the comma would go with it.
So across the board policy, comma, go away.
Just across the board. You need policy.
Just, you gotta keep the word policy, I think. There's uniform policy, on a no property owner compliant complainant in a single. And that next whole section to me is much more of a background than policy. It's literally describing the Board of Revision process. When I read it and I'm trying to read policy in it, I'm reading a description of a process and not policy. So can we put background to benefits of district and constituents or something that kind of lets the public know that this is background to support the policy that will be coming after it? Does that make sense?
It does.
to anyone else?
Does that make sense to you?
Where would you want that?
Want
Just
the
add
background,
the word
the word
background
benefit
in the
in-
title.
Right, background benefits, to district, the background of Board of Revision policy. And something, there's, the title, I think, needs to be.
Background on benefits.
I mean, I would almost turn it into a definition section and then organize it differently, but that is a lot. to-
I like
Yeah.
keeping benefits to district and constituents because it calls that out clearly, but adding just the word background in
Yeah,
front of it, I think that's what you have.
Well, benefits and.
Be background colon.
Yeah.
Yes.
Yeah,
Yeah.
that works.
Yeah.
Is it background colon or benefits?
And then in the first sentence there, we use BOR, but it's never been defined yet. So.
no, it hasn't been spelled
Oh, yeah.
out.
It is in the title, but yeah, you're right. It should be in.
It's gotta be in the
text.
body now. Mhm.
So right out Board of Revision.
Order of vision.
And parentheses, BOR. Then my next, filing the counter complaints, how did we arrive at the 50,000 in true value? And what does true value mean?
50,000 is statutory. It's actually written in statute is $17,500 in taxable value.
Gotcha.
Taxable value is 35% of true value.
Okay.
True value is market value.
So it's statutory.
Yes.
Should that be noted in there? Because.
It's
it
not,
looks
we
like-
didn't come up with the amount.
Right,
Yeah, that's a
Right.
great point, yeah.
the source of that.
Well, but you can set whatever number you want. That was the number that was set.
So we could set it at 100, is what you're
You can
saying.
set it at whatever number you want, yes. But
So-
one thing to keep in mind is that is what's requested on the complaint. There are attorneys out there that will fill out the complaint form and write 17,499 in tax, 49,000. When they get to the hearing, they ask for. They're not bound by what they ask for on the complaint. But
And what
so
are we
if you,
describing here?
so if you change, if you change that,
What's on the complaint form?
let's say you wanted to increase that to 100,000 in true value. And the property owner files a complaint for a reduction of 90,000. Well, you wouldn't file a counter complaint because it doesn't meet your threshold. But at the hearing, they go in and ask for 200,000. It's too late. You can't do anything about it.
Yeah,
But they can do that.
Oh, absolutely. It's only an opinion of value that's placed on public complaint form. And there are practitioners that do only this for taxpayers. And they know how to play the game. And so prior to House Bill 126, the auditor was required to give the board notice of any complaint that sought 17.5 is what it's referred to, or $50,000. I've seen hundreds of complaints that were 17.4.
So how do we protect the district from the gate?
Well,
He's saying.
And that's
you
just
you
that is
protect
the
it by
way that-
keeping it there.
Okay.
But then there was also a legal protection because it's only an opinion, and this is prior to 126. This is one of the issues that was never thought of or cared about when they passed 1.6 is we could file the counter complaint within 30 days of receiving notice of the complaint. And case law said that if they asked for 17,499, we didn't file a counter. They go to the hearing and ask for 20,000 or 100,000 more, and the board hadn't given us notice because it was under 17.5, they have to stop the hearing and give you notice. So you file your complaint. You have a right to intervene at that point because they changed the complaint. But that only works when your 30-day period starts from the date you're notified.
Yeah.
Well, they eliminated notification and you file it 30 days from the date it's filed. And they don't tell you it's been filed.
That's really messed
So
up.
they're making the game harder to play.
Or-
And they're giving savvy property owner attorneys more avenues to hide things or to circumvent and keep boards of education out of it. Which means then that boards of revision are going to grant reductions based upon something less than competent probative evidence. And we're not there, or we have to try to repeat.
But we've been in contact with our Frank.
We're
our
working
county
with the
They know
auditors.
this. They're gonna have the information, so.
We've already started receiving
new
counter
plans
or
for me to make
reduction
sure we get
complaints.
that, so we don't miss.
We're already processing those as they come in. They're giving them to us more often than weekly at this point. So I'm fully confident in Franklin County's procedures. But we're backing that up with public records requests so that if something slips through the cracks, that we at least have an argument to say they didn't comply with public records requests, and so we can't be held to that 30 days. I don't know if that's gonna work, but we'll see when that happens. But we can put the word statutory in there if you want. Or it could just be that the board is going to accept that that's gonna be your number and that's okay.
Well, I mean, I think we should say, I think having that statutory wording in there lets people know that we haven't arbitrarily set this
Yeah.
number,
Yeah.
right? And it would be a trigger if a board member comes on 4 years from now and you're reviewing this and you're like, gosh,
Right.
the statute, right? Because Neola's not supervising this one yet, right?
Correct. 'Cause it's
So
brand new to them.
having statutory in there and having the ORC reference,
we would reference.
I mean, how, you know how the Neola does it at the end?
Yeah, we would have to, right? Are we going to?
It's not on any of the drafts.
It should be. We should be, I think, just referencing the revised code sections at the bottom. So the way that I don't know if you see our other policies, but.
No,
Yeah, I don't know why you would have, right? But all of our board's policies that we have list whatever revised code section.
And you
I think that would help.
Yeah.
may know that number off the top.
57, 15, 19,
I would have to.
That's, I knew it. 57, 15, 19, got it.
and the appeals is 57, 1701
Yeah.
and 2506.
Thank you.
That's impressive.
I'm just blown away.
And
Okay.
then-
Okay, so the fields is 57.
57, 1701 is the appeal of board of tax appeal. And 2506 is the common pleas appeal section that brings
57, 15, 19,
19.
57, 17, 01, and 2506.
I think it
All
makes
revised code.
more sense to do it that way at the bottom.
Got
than
it.
Yeah.
to
I got those.
yeah,
I got
Do
those.
anything
Yeah.
in the language within.
So I just want to make sure I'm understanding something, because I've had a lot of constituents talk to me about like their concerns over taxes increasing. This change in the law puts their taxes at risk based on how they made this gain. I mean, like, we're putting plans in place to not put their taxes at risk, but the law did not.
I don't know that it
No.
didn't.
There's no additional or less risk to any particular taxpayer based upon.
But wasn't it that we had the conversation last meeting that if the appeal process didn't happen,
That's how it was before the law changed, and that's how it is after.
Yeah,
the law
nothing really
changed.
has changed.
That's both.
But if they're making it
If
difficult to do it.
if we didn't do the appeals, values could go down.
Yes, and tax rate would go up.
Yeah.
So
So I think that's what
Yeah,
she's trying.
that-
So the
that's-
law makes it, they're making it complicated.
even harder
It puts it,
to
it puts that at risk more.
other
And we're-
taxpayers.
Yes.
I guess that's a fair statement. I suppose, I mean, by making the process harder.
Well,
for
it is
school
overall,
districts
if
to
you, if you think of it from an equalization
Yeah,
standpoint,
that's
which is
true.
what we're talking about. We're
Right.
talking about that an unwarranted reduction in one property is a tax increase for every other taxpayer
Right,
in that district. Yes, that's the equalization argument.
yeah,
And that's been a problem actually since 1910, is when the equalization issue came about. But that was the Smith Tax Act. We all thought it was House Bill 920, but it's not. It was back in 1910. Nothing has changed. What has changed is prior to 126, every taxpayer, any taxpayer in the county could file on any of the property. We talked about this at the last meeting. However, the way the system was set up, the Board of Education was really the guardian of the other taxpayer because you were the lion's share recipient of the tax dollar, so the Board of Education is the one who had the most incentive to file complaints or defend against reductions. Okay. This makes it more difficult for Board of Education to do that. A individual taxpayer could do it. But the benefit to an individual taxpayer to file a complaint against one other person is small.
yeah.
And it's so small that they're not gonna have any incentive to do it. But when you talk about it in collective, it's millions of dollars. So yes, it does make it more difficult because the one entity that has the largest stake in those tax dollars is being given more hurdles to accomplish an equalization process.
Thank you.
Any other
Does
questions?
that pretty much satisfy everything, Daphne?
Yeah, that has. We added the.
I just had one comment on your comment with the true value. Do you want it to have a parentheses with market value to clarify that, or is that overkill?
True value is a constitutional term. That's what's in the Constitution. That's the uniform rule of taxation. That it's true value in money is what the Constitution, the
And I
Ohio
think we
Constitution.
need to stick with it.
Yeah.
Yeah, I think we need to stick with it too. I also think that, I mean, this is something that always comes up at levy time too, is people trying to understand what all these terms mean. And so I think it's more about just, we have to figure that out through whatever general education our treasurer provides to our community.
You said something earlier that I've already gone down a different path in my head of thinking we almost need a school finance
Yep.
glossary of terms.
Yep.
For this and everything else that we talked about.
Yep.
Maybe we can put
Yeah.
on the website or something like that. That would be
Yep.
very, very helpful.
All right,
Okay, thank you for everyone's feedback on that.
love and policy.
For your help, Mark. This
Thank
was-
you, Mark.
You're welcome.
Thank you.
It's never easy doing a brand new one for the first time. Yeah. Neil will thank us when they have something that they can then look at. It'll be in their book of,
Somebody get it.
they'll be booking their book of policies. So I have the changes here, so what I'll make sure is that I'll send that out so everybody can see the changes,
Okay.
just to make sure that there are any, grammatical or spelling errors or anything, so. Okay, thank you, sir.
Good to see everyone
Thank
again.
you.
You too.
Thank you.
All right, so now we can switch gears and
Yes.
we'll go back up to the top, and the next policy is policy 2280, and that's preschool program.
Yes, this one is a benefit to our district in that it provides regulatory changes that modifies the definition of preschool, general education and integrated classrooms. So it gives us more flexibility for offering our preschool program. It's less confined ratios for number of students with disabilities and not. So these were good changes.
Right.
Any questions on 2280?
I saw where we have the guardian reference down there at the bottom of page 1. Parent/guardians. And then at the top of 2, I mean, it looks like it's throughout.
It's-
Yes, and it's
That's a different
appropriate in
version.
this case.
Okay.
Yep, it's appropriate in this case because it's just access to the students and their information. Okay, the next, Rick?
2413, and that would be career advising.
Yes, so the
Like it's-
the belief behind this bill, as far as I understand, is that it's just making sure that school districts are doing their very best to let students know of all of their career options. And so it does ask for a provision to be added of ways that students can offset the costs of post-secondary education that you see listed there. Reserve officer training, college credit plus, pathways. And so that it's just incorporating those changes from Senate Bill 135.
Are those, I'm just curious, are those specific options listed, are those coming from the model policy, from the bill? Are they our ideas? I don't, where are
Yes.
those coming from?
So we had an option of taking 5 and we took 4 of those because they're relevant for our district to see struck in red, the one option we did not take.
But those options are not things that they are options. I guess what I'm trying to say is this is not necessarily an exhaustive list of ways to reduce costs. So I'm assuming these are what they told us we had to tell students.
That's
Is
right.
that a correct assumption?
These are the ones that were identified by the General Assembly.
That's, okay, thank you.
And these are ones that can happen in high school.
Yes,
We have a reserve officer training corps.
we do not currently, but they can happen in high school.
I think, Southwestern City has some, I think Westland.
So we put it, I mean, I just don't question why we have it in our policy if we don't offer it.
We do not. I would have to check with Neola to see if we have to take this one. I know the one we struck in red, we did not have to take. But I can ask Neola on this one.
I mean, I think we should. We have nothing that we offer. Like, I mean,
But it may be that the General Assembly is purposely wishing for everyone to put this in the policies to show community members that this could be an option.
Well, if we don't have a plan for it and a way to execute it, then we shouldn't include it. It's my opinion.
Is this the, see, I
Does
am
Eastland
reading it
Fairfield-
differently than you are. I thought this was talking about reserve officer training for at the college level to help.
That's
reduce-
why I asked. These are other, the rest of them are all things that happen, right, during the high school year.
I don't know, but doing a high school ROTC program does not reduce the cost of college. Doing college level ROTC does. That's why I
It's a
assumed that
pathway.
it was referencing college level, not high school.
Well, then how do you strike the last one?
I don't know.
I mean, to me,
The whole thing doesn't make
e-
sense. That's why
either-
my original question was, where is
Right?
this language coming from? And if it's coming from the legislature, then that
so the
explains why
logic
it
of
doesn't
why
make
we
any
struck
sense.
the last one is why I asked about the first one, right?
I know the last one was given to me as an option.
Do we still have options for education?
I will dig deeper on this one.
Okay, thank you.
Mhm.
When I first read through them last weekend, I thought it was something at the college level.
It's a really interesting list.
Yeah,
Yep, I will ask you about this. All right.
Next, we have 2 together. First is 2430. And that's district-sponsored clubs and activities. And then along with that, 2431, interscholastic athletics.
Right, both of these come out of Senate Bill 181 and address the the fact that school districts are not allowed to limit a child's wearing of religious apparel for a sporting event, for an athletic competition.
I actually thought we had already made this modification,
I did
but
too.
maybe I'm losing my mind.
No, I agree. I thought we had already added it, so
The law became effective last May.
I feel like it just got missed, yeah.
I mean, it just didn't actually happen. Moved from
Yeah.
policy committee
Right.
to a regular board.
In the dress code, there's a mention to that. I'm not sure the exact.
didn't take all the policies.
Well,
That
that
reference,
Oh,
we
This-
changed it in one and didn't
Do it
In our
in,
in the ones that
That
cross
could be.
reference, right?
that could be,
There's a lot of them.
yeah, that could be.
And these policies also mention an exception when there's a factor of safety towards the athlete or as anyone else. So there are exceptions. But any other questions or comments?
So, Mr. Manley, if you agree, I'd like to take 5111 and 8320 and 8330 all together. Two of these policies deal with students or student records, the other with staff or personnel. But this reflects a change to the Secretary of State's Safe at Home program under House Bill 93. And what this does is it now asks for individuals to provide their program authorization card when. So these are real simple changes to the.
Okay, so House Bill 93, that's regarding policy 5111.
8320 and 8330,
Okay,
and we did remove guardian, Mrs. Maury, in those.
so that's eligibility of residents, non-resident students, personnel files, and student records. Okay,
Yes, and it pertains really to the Safe at Home program
okay,
and how to show eligibility.
okay.
The next one, Mr. Manley, is 5336. And this is related to medications used by persons with diabetes. And that if a nurse is not on site and instead we use a person trained in care for persons with diabetes, there is an extended list of trainings that that person needs to be engaged in to keep the students safe.
We have a lot of students with diabetes.
I don't know the answer to that.
Just curious.
I don't know.
You know, when my sister was a school nurse in Groveport, the number of students was amazing. That they had to test after lunch. Yeah.
So I want to get those kids with the.
But now they
patches on.
have. some
Now they have
kind
more
of
tools,
tools,
right?
Yeah,
Yeah.
Hopefully that's made it easier on our school nurses and
and
secretaries.
parents following along on their apps with
Yes,
monitoring
yeah.
it.
Ready for 67?
6700, Fair Labor Standards Act, FLSA.
Yes, this is an amendment to the Fair Labor Standards Act. And really what this does is it adds language that summarizes our board's obligation to provide reasonable breaks and private facilities for Fair Labor Standards Act eligible employees for lactation purposes. It also includes the optional language that provides that same benefit to Fair Labor Standards Act exempt employees. So that we're offering similar, not the same accommodation.
That's great. Comments?
Is that something new?
It was a law change a little while ago.
Yes. We
I
don't have
did,
the
I
date.
I don't think so.
Did it work?
The next one, Mr. Manley, is a new policy, 7440.03. And that is the drone policy. So as we're building our new high school, I suspect we might have some drone flyers want to explore that. And if you accept this policy, we will be asking that they do so with our permission. And it does allow for construction companies, our contracted construction companies, to use their drones over the construction site. But non-previously identified companies need to come to us for approval. All right.
Moving to 8210, the school calendar.
Yes, if you were missing talking about blizzard bags, yes, they're still being talked about in the General Assembly. So really, the major addition here is that if we do choose to use blizzard bags in a year, we need to adopt that plan by August 1st of that school year. So.
Can we, the third paragraph, can we, when do we offer the public hearing on the school calendar?
Thank you. That was my question too.
Well, I don't know if in the past, has the survey been considered for the public?
I think that that's something that we should have some internal you should have
Yep.
some further discussion about internally.
Yep.
And maybe come up with a recommendation for us about, I mean, I suspect that something that we've done has been construed as a public
Sure.
hearing. But
But if we're gonna rely on a survey, I think we should say, or
I mean, we can have a public survey.
Right.
Portion of the agenda when we approve the calendars. I mean, it would just be a separate, I guess what, for example, city council says is you would still have your public participation section of the agenda, but you would also have you would formally say you're opening the public hearing. And
Yes.
closing the public hearing.
Yes, like they did with the adoption of the new city hall. Right, okay.
Yeah,
it's gonna have in policy, we're gonna have to do.
right. Like I said, I'm sure that there is something that we have regularly done that has been construed as the public hearing. But
Okay, I will make sure we take care of that.
And lastly, 8600 transportation.
Yeah, this one isn't surprising really when you read it because of the concerns that many of the districts are having with transportation. Really how this reads is if you start the year transporting students within a tighter radius than you legally have to, you can't go back to the expanded legal radius simply because transportation has become cumbersome or an issue in your district. That however you start the year for your transportation radius, you must continue the year ahead of it. Which is good to know.
Yeah.
Sorry if I'm screaming.
That second sentence in the third paragraph. Maybe I just can't make the transition from the first sentence to the second sentence. Where are you? Third paragraph down.
Is this the one you asked about earlier? Mrs.
Yeah.
Murray?
Because the second sentence, the new sentence doesn't just relate to temporarily or permanently disabled children. It's global, right? So to have it in the same paragraph as the conditional limited subject is off center to me. you see what I'm saying?
Which paragraph are you on?
The third paragraph, so the original sentence is exceptions to the foregoing limits may be made in the case of a temporarily or permanently disabled child who has been so certified by a physician and in the case of adverse safety conditions. Then we added this new sentence that I think is global, not
Yeah,
just.
yeah,
related.
it
I
is.
think-
You're right.
And I just can't get the two to connect.
Mhm.
I see what you're saying.
Okay. So we need to have some more context to the reason for that, that sentence. Whether it does indeed pertain only
Or-
to,
Or it's a one sentence paragraph all by itself,
Right.
right?
Mhm.
And it should go above the exceptions, right?
Right, because it's more global.
Right.
And then you're talking,
And then you have.
then you
the
start
exception.
talking about.
Right.
The disabled child and the vocational. But I think that sentence is meant to be global.
I will check. It also further defines the 30 minutes, which is interesting because I know a lot of districts have, from the time I was on the State Board of Education, that was a hot topic of how you establish 30 minutes.
Oh, yeah. I like that.
That was, is it as the crow flies? Is it as- That was-
Big-
it's lots of public testimony on that when I was on the State Board. But yes, I will ask more about that sentence.
I'm sorry to go back, but this was very, I had 7217. Is the term conveyance a term that's widely known? Like 7217 is weapons.
I looked it up, yeah. it's-
Did you look it
I
up?
didn't, yeah. I think it pertains to
An individual who has been issued a concealed handgun license that is valid at the time of conveyance.
Conveyance is a term that our SROs and the chief uses with me often, so I believe, I can't say 100%. It's a
I
term
think it is a term of art. I mean, I think that is the specific word used in that particular
Right.
law.
So what did it mean?
I
When he
don't
was
remember,
issued
but
the
I was like,
gun?
oh, it's about guns, yeah.
Or issued the license? I mean, it's. I just want policy that people can
Can understand.
understand to implement.
Conveyance is the legal
Not
process of
interpreted.
transferring property from one owner to another.
So when they purchase the gun,
They did it legally.
Transfer. Ownership, carry.
and that's what they have to use because you could purchase illegally, right? So we can't say purchase.
Right.
Yeah.
Exactly.
All right, now we know why they use conveyance. Okay.
They could just say legal purpose.
Add that to the collaborative.
Yeah, yeah, it's come out with
Yeah.
finances and everything.
Reading policy, sometimes you have to use Google.
Yeah.
Well, and I think I have it all, and then, great, there's more things that percolate.
Yeah,
Yeah.
I never have it all. So, I have my list of items to drill down on, and I will put answers in my report back to you.
all right.
Great.
Yay.
17 policies.
Thanks,
Wow, that's
everything.
impressive.
There you go.
Yeah.
Thanks, everyone. Good teamwork.